All right, so good afternoon, everyone. It is November 7th, 2024. I'm going to call to order the meeting of the Sentencing Guidelines Commission, and I'd like to ask Nate to go ahead and take the roll.
And Madam Chair, before I take the roll, I unfortunately must announce that I will not be calling the name of Christopher Crutchfield. We learned this morning from Commissioner Crutchfield's family that he passed away unexpectedly on Monday. So unfortunately, his seat is vacant. Roll call, Vice Chair Larkin. Larkin absent. Commissioner Fraze. Fraze absent. Commissioner Keefe. Keefe absent. Commissioner Knudsen.
Present.
Commissioner Knudsen present. Commissioner Ladd.
Present, and I would just say, Nate, that I do see that Commissioner Larkin seems to be in the attendee room, so I don't know if she can hear you.
Thank you so much for pointing that out. I will make sure to elevate her.
So is Commissioner Mueller. And
All right. So we had begun the roll call, as you probably heard, and did not realize that several of you were in the waiting room or in the attendee room waiting to be elevated. I apologize for that. So I'm going to acknowledge that Commissioner Ladd is present, and then I'm going to go back to the beginning. Vice Chair Larkin, roll call. Come back to Vice Chair Larkin. Commissioner Keefe.
Present.
Commissioner Keefe present. Commissioner Middlebrook.
present.
Commissioner Middlebrook present. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Morin.
Present.
Commissioner Morin present. Commissioner Mueller. Commissioner Mueller present. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena.
Present.
Commissioner Saxena present. Chair Mitchell.
Here.
Chair Mitchell present. Vice Chair Larkin. Vice Chair Larkin, just for your information, Vice Chair Larkin, we have.
Nate?
Yes, ma'am.
I'm here. I've been trying to unmute myself since 1 o'clock for the first time.
Okay.
Thank you.
Excellent. All right. Vice Chair Larkin present. Thank you, Madam Vice Chair. So that leaves Commissioner Fraze absent, and I don't see him or see. Just check the attendee list once more time. All right. Don't see him out there as well. So it appears that Commissioner Fraze is absent. So Madam Chair, there are 11 members present, 1 member absent, 1 seat vacant.
Okay, and with that, we have a quorum. Before we get to the business today, I do want to go back to the fact that we lost a member of the commission this week. And I think it would be appropriate for us to actually begin the meeting with a moment of silence for Commissioner Crutchfield. Thank you. I also would open the floor to anyone who would want to say anything about Commissioner Crutchfield. I will say, it's hard for me to say anything. I got to know Commissioner Crutchfield really in my previous position as director of the Robina Institute, we did a project with Ramsey County when he was there to work on probation violations. And I just found every interaction with him to be a joy. And he was incredibly smart, really thoughtful, a real asset to that project. And then a couple of years after we started that, I'm attending my own son's high school graduation where we were at the awards night prior to the ceremony, and I walk in and there's Commissioner Crutchfield, and his daughter was also graduating from that same school, and neither of us even knew that our kids went to the same school. I got to sit next to him and one of his younger sons, who, as it turns out, is in my younger son's grade as well. So the two of them will be graduating this year together. It's devastating news, and I'm gonna miss him. And if anyone else would like to say anything, I'd open the floor to that. Commissioner Moore.
Thank you, Madam Chair. Every once in a while in your life, somebody comes into your life for a moment that you have a sense you would like to get to know at a deeper level. And that was Chris Crutchfield. And now I sit here today having not done what I sort of thought that I should do, was to get to know him better, because I was really impressed with his perspectives and things that he talked about, but the way he talked about it and the way he drew people in and acknowledged other people's perspectives. You know, he obviously had a point of view and wasn't shy about expressing that. But when he talked to you, it was never in a way that, you know, suggested that he needed to explain to you why you were wrong. I mean, it was like, here's something you might want to think about. And on a slightly lighter note, he got me interested in a certain type of dog breed that he's apparently, he and his family have these like hairless, I can't remember that, I was trying to find the email, hairless type of like, hypoallergenic dogs. And he showed me the pictures of these dogs. And I was trying to think of whether this would be a breed that my son who's got some allergies would like. And, you know, just little things like that just struck me as a person of great conviction. And sadly, I knew who his brother was who passed away, the Dr. Crutchfield. That didn't happen that long ago, and that's, you know, what a terrible blow for Commissioner Crutchfield's family. I feel so sorry for them, and it's a loss for our group, Madam Chair, without a doubt, big loss.
Anyone else? Anyone on staff, do you want to say anything? Yeah, come on.
I would like to say a few words. I was very fortunate before I came to the sentencing guidelines to work alongside Commissioner Crutchfield. Actually, he was on the hiring panel that hired me to Ramsey County Community Corrections. And during my time there for about 15 years, I got to work beside him and to watch his commitment and devotion to the work and particularly to his community, and always was blown away by that conviction. And then I got to know him personally, and I can consider him a good friend. And it's just really hard to believe he's gone. And just, he always had a smile on his face, and he always made you feel special and told great stories. He loved to fish. He loved his family, his kids, his wife, and I will miss him dearly. And we were very lucky to have him, and we'll miss him.
I'll say, thank you. Commissioner Crutchfield, when I first met him, I had heard of him, but never got to meet him in person. But his name reminded me of my son's doctor years ago, who was miraculous with my two sons when they were younger. And I asked him, was he related to this person? He said he was. And so that's when we started having conversations. Commissioner Crutchfield was a good guy. That's real sweet. He actually got me interested in potentially trying beer. Different kinds of beer. And I thought that was nasty. And I said, you know what? He convinced me to try different flavors. So just a really sweetheart. Going to definitely miss him. Concur with what everyone is saying, but just a very sweet man who just wanted to see the community better, especially community corrections. So we'll be missed.
Thank you. Anyone else? Commissioner Knudsen?
Well, I got to know him just on the commission here for the same reason Justice Moore talked about. I had heard of and knew of his brother and his brother's, some of his patients were friends of mine. And as Justice Moore mentioned, his brother had passed away. His first meeting, I got to sit next to him, and of course, the first question is, are you related to the doctor? Of course, it's his brother, and kind of off we went. But he's got the kind of background and the breadth of experience and the commitment to improve his community. It's getting to be a rarer and rarer breed that is willing to volunteer and to commit this kind of time. But we needed that perspective. He gave us that perspective. He was very thoughtful and a deep thinker, and much appreciated on the commission.
Thank you.
If I could say a couple things as well.
Absolutely.
I
Please
don't
go
know
ahead.
if you can. Thank you. I just wanted to say I also met Chris through the commission, and such a charismatic person that was able to make relationships with people in a very short period of time, which I think is really an incredible trait that he had. In the short time that I knew him, he invited me to attend his recent Ujamaa Place annual breakfast, which was really an incredible opportunity to see Chris in action and the great work he's been doing for justice-involved men over the last year as the executive director of Ujamaa Place. And seeing a lot of these men talk about Chris and the impact that he's had on their lives in just a year was really amazing. It was also really wonderful that he was able to have a pretty famous author, Eddie Glaude Jr., speak at the event because he'd gone to college with Mr. Glaude and stayed in touch with him for so many years. And it was also really great to meet his wife and his daughter, who's thinking about going to law school, I think in large part because of the impact that Chris has had in her life. So I'm proud to have known him, and I'm very saddened by the loss.
Thank you. Well, thank you all for taking the time today. It's the very least that we can do. But I'm glad we did it. So with that, we have to turn to the business at hand. And the part that will help us all get our emotions in check is that we have the very boring task of approving the agenda and also the minutes. So I would entertain a motion if anyone wants to bring a single motion to approve the agenda and the minutes. I would entertain that as well. So Commissioner Reeves moves to approve the agenda and the minutes. Any seconds? Commissioner Middlebrooke seconds. Any discussion on item? None. I would ask Nate to read the roll.
To the Reeves motion to approve the draft meeting agenda for today's meeting and to approve the draft meeting minutes from October 10th, 2024. Larkin?
Yes.
Larkin, yes. Phrase? Phrase absent. Keefe?
Yes.
Keefe, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morin?
Yes.
Morin, yes. Mueller? It's just got the tail end of that. It sounded like an S, but I'm guessing it's yes? Yes. Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
And with that, the agenda and the minutes are approved unanimously, or the motion is approved unanimously. So that takes us to item number 4 on our agenda, which is the stay of adjudication as custody status. And I assume you're going to walk us through a little bit here.
Yes, thank you, Madam Chair. And I hesitate to get into too much detail because we did get into quite a bit of detail in this 2 months ago when we talked about the Woolridge Carter opinion, which held that that a conviction is not necessary for custody status. So if somebody's on probation for stay of adjudication, as long as the person's entered a plea of guilty, which is generally how a stay of adjudication works, then that person would be considered to be on probation and therefore have a custody status. When we walked through the guidelines history, which originally held that a conviction was required for custody status, unless there were a couple of exceptions, and those are basically in the beginning it was release pending sentencing. So if somebody had pled guilty and was released pending sentencing, then a conviction would not be required in that particular case. And gradually, there was some confusion thrown in because the commentary talked about a particular type of stay of adjudication that also qualified for custody status. And back then, the courts actually gave greater weight to commentary than they give now. Now, the commentary really isn't considered to be something where policy can be contained. Rather, it's just more illustrative of what the commission's thinking is when it wrote the policy. But at that time, the 152.18 policy was only in the commentary, and that was given weight. But it was also limited by a case called Roloff to say, even though some of the languages may be broader than that, some of the rationale could apply to any stay of adjudication, we're going to construe this 152.18 exception as being limited to stays of adjudication under Chapter 152.18. And then there were a number of different changes, none of which were related to stays of adjudication that kind of changed the wording around. Ultimately, the stay of adjudication language related to Chapter 152.18 was brought into the sentencing guidelines themselves, but everybody understood based on a roll-off that language was limited to 152.18 stays of adjudication. Then the commission decided to repeal the stays of adjudication limitation for 152.18 because it didn't make sense in the commission's view to just have it for 152.18 stays of adjudication and not all stays of adjudication. So they just got rid of they thought they were getting rid of the stay of adjudication authorization altogether. So a conviction would be required for most custody status types, similar to how the guidelines were originally written. But then the Supreme Court, actually the District Court, Court of Appeals, and Supreme Court in Woolridge Carter agreed that decided that in fact the way the guidelines were written, even though it was never a decision of the commission at any point in time, because of the literal language of the sentencing guidelines, where it authorized a conviction or a plea of guilty or a verdict of guilty to trigger a custody status, and it didn't make it clear that the plea of guilty and the verdict of guilty only applied to pre-sentence or release pending sentencing or confinement pending sentencing. Then because the language was not clear that way, they said that a stay of adjudication was sufficient. So probation under a stay of adjudication would have been sufficient. So as we pointed out in the paper, the commission has basically 3 options at this time. The first option, let's see here. Is to do nothing at this time. Second would be to change the guidelines, commentary, or both to be explicitly consistent with Woolridge Carter, although that's not necessary because based on the Woolridge Carter decision, that the guidelines are consistent with Woolridge Carter. Or the third option is to change the guidelines, commentary, or both to nullify the effect of Woolridge Carter with respect to future cases. And that's the language that the staff has written up. And the staff's rationale in writing that up is that because there was never a point in time where the commission decided to make stay of adjudication probation in general a qualifying custody status, that basically would be a return to what the commission's previous intent was to abrogate Woolridge Carter. So the language that's written would require that the custody status must have, for custody status at the time of the offense to increase the criminal history score, the proposal is to require that custody status must have followed conviction, with limited exceptions for the custody statuses of pre-sentence release and pre-sentence confinement. So at this point, the commission could move that language or move other language. It would be then subject to a public hearing in December and final action in January. And that public hearing would take place right before the commission's meeting. So it would basically be at the same time, but the commission could not take action under the current meeting rules, under the current public hearing rules. The commission could not take action just in December. It would have to wait 5 days and then take action in January. So,
Commissioner Middlebrook?
Thank you, Madam Chair. I would move to abrogate the decision of Woolridge Carter and change the guidelines consistent with the staff drafted language.
Okay, so you've made that motion. Do we have a second? Second. Commissioner Reeves, second. Discussion on the motion. Commissioner Knudsen?
I would oppose the motion. I'm not clear, this is a long history of things changing and happening in the, apparently on the commission that none of us involved currently were ever involved with. And just thinking that the purpose of the custody status point, I think applies to a state of adjudication, as the Woolridge case says. I mean, it was a conviction, or it wasn't a conviction. It was a plea of guilty, and they were placed on probation. So the whole discussion is, the custody status point is to help deter further offenses and compel cooperation and completion of probation. The other, that's just my thought on the policy itself. The other thing is, who is operating under the, we've got the appellate court decision that came down in, was it 2019? And then it finally gets to the Supreme Court. And so we've got different ways of operating and applying the custody status. The Supreme Court looks at the plain language of the guidelines and says this is what it says. And then we're going to now go back and say, well, that's not what we ever meant. And then we're going to go ahead and study the custody status point and maybe change it again. So I'm wondering if this whatever action we take is going to happen till January. Why don't we give it a little time to stew and see what role this case plays in our overall discussion of what we do, what proposals we make, how we approach the custody status point overall and in general, and not change things on an annual basis. So I for all of those reasons, I would oppose the motion.
Okay, so I think Commissioner Middlebrook, I'd like to give you a chance to respond, and then Commissioner Larkin has her hand up, so we'll go Middlebrook, then Larkin.
Thank you, Madam Chair. The reason that I'm supporting changing the guidelines with the staff drafted language is because, contrary to what you said, Commissioner Knudsen. I was part of the commission when some of these changes took place. I was here in 2019. And one of the things, if you go back historically, the stays of adjudication, other than the 15218, they were never counted for custody status point. And in 2019, when we were doing some changes to have some consistency and looked at this, in 2019, the intent then and what was the intent going forward was that all stays of adjudication would not be counted for the custody status point, and they've never been counted for criminal history score because there's not a conviction. The way that the commission back then and what way I see this is that stays of adjudication are more like pretrial diversion programs and trying to be consistent with different parts of the state and how different programs are utilized, they come out to be really the same as the pretrial diversion, which of course they're not. They're excluded from the custody status. So based on that, it was the Guidelines Commission intent that they not be included. I recognize that the Supreme Court's decision looked at the very plain language of the guidelines, but not the commentary. The commentary stayed the same, which reflected what the intent was. The other thing I just add is that it seems different than the case where someone is released pending sentencing, because at that point they have either been found guilty by a jury or pled guilty, and there's going to be a conviction when you get to sentencing. So it's a different status. These are usually very low-level offenses. Other than the 15218s, the prosecutor has to consent to those. So they're in a very different category, and that's why I'm supporting the motion.
All right. Commissioner Larkin.
Thank you. I speak against the motion, but not substantively, but because of our procedural posture right now. We are 1 year in to a comprehensive review of all aspects of the guidelines. And at our last meeting, we agreed that it's time to, stop studying, get to work. We've identified the areas where there seems to be compromise and a desire for change. One of those is the custody point. It's been something that's been on the table for 2 or 3 years. So we are going to be talking about the custody point next year. Should we have it? If so, to what extent should we have it? And it seems to me just not necessary to carve out this one aspect of custody status use and decide it now, because the reality is we're not dealing with a situation where the district courts need guidance. The Court of Appeals issued a published decision on this issue, so that has been the law for a year or more. So we're talking about changing that law, even though months from now we're going to be looking at the custody status point, everything related to it, as well as all of the rest of the guidelines to come up with a more comprehensive solution. And I think that our best shot of really making some changes to the guidelines that will be acceptable to everyone will be through compromise. I mean, if we vote to do this today and it goes to a public hearing in December, I have no reason to think we're not going to get the sort of backlash we received when we took to a public hearing the notion of eliminating the custody status point altogether. And the backlash may be even worse if the public is asked to weigh in on this and told, the sentencing guidelines is doing this to essentially abrogate a recent Supreme Court decision, which affirms a rule of law put in place a year or more ago by the Supreme Court. I just don't know that going forward now is the best recipe for success. I would rather wait, make this part of our comprehensive review, try to come up with a way that addresses it that's part of a bigger compromise of all the issues we're going to be looking at next year. So again, I'm not going to speak against it substantively today. I just speak against it in terms of our current procedural posture.
Any other discussion?
I just had a point of order question, Madam Chair, if possible.
Yes.
My computer just crashed. Could you please restate the motion that's been made for me?
So the motion is to basically adopt the staff recommendation to amend the guidelines. Want to restate it?
Yeah, so the Middlebrook motion, as I understand it, is to abrogate State versus Woolridge Carter consistent with the staff drafted language and subject to a public hearing. And just one point about the sequence, just to correct one thing. So while the commission's final action would be in January, this change would not take effect in January. The change would take effect August 1st of 2025.
Commissioner Larkin.
And on the point of order, and I'm sorry, I might be completely mistaken. I think we might have skipped on the agenda approval of the meetings. I thought Commissioner Saxena was going to raise that. So we probably have to come back to that for this issue. And I would just chime in now that Nate has pointed that out. Well, you know, why make a change now that won't take effect until August if next year we're going to be considering whether we continue with the custody status point at all, and if so, to what extent? Because then we're just going to be having another change on top of that change. It seems to me the more prudent course is to just leave things as they are and tackle this all next year.
So just to address the motion, we had a joint motion to approve the agenda and the minutes. So we did
My
take care of
apologies.
this there.
My apology.
So the comment that I'll make is what I'm concerned about is that the Supreme Court ruling, while it may have, while it accurately read plain language, it did not accurately read the commission's intent. It didn't get to the commission's intent. And so it is changing the way that custody status has been calculated under our guidelines for a number of years, and goes against the intent that the commission had put in place. And my concern is that the research that our staff did on the potential impact, and that the number of cases that this now could be included in custody impact could have a prison bed impact as well, and that a significant one. And it's our job to also be managing those resources. That is, in fact, one of our charges. So I think it's irresponsible not to take this up when we know that this is a problem that could lead to additional beds unintentionally being, put in place. So I really do think we have an obligation to bring the guidelines back into alignment with the policy that we thought we had enacted. I agree that we may be, that we will be, we'll be looking at custody status more holistically over this next year as part of a bigger look at criminal history. And it's bad timing. The timing sucks. I'll just own that right there. The timing is awful. But I still think that given the prison bed impact, we need to take action in order to fix the issue for the time that the guidelines will remain in effect, which is likely to be several more years. So I think it's too big of a risk to not address the issue today, and I would be voting for this motion. Commissioner Fraze.
I guess I have three questions. One, just on the point about the bed impact, that would be after August 1st, right? Because right now, the state of the law is that it does count, and that will remain the law until action of this commission will begin effective next August. I guess on the way this is probably in this issue paper, and maybe I didn't pick it up. Two questions about how these stays of adjudication work. One, is it required, or at least customary, that the that the defendant has tendered a plea of guilty, even if it's not been accepted and entered as a conviction. And secondly, whether or not a plea of guilty has been tendered or entered, is it customary, highly likely, in fact, that prosecution will be resumed because of the current offense, and therefore there will be consequences to the offender for the current offense happening under while released? It's pretty serious consequences resuming prosecution. I assume that is the normal way this works. So the two questions are, is a guilty plea at least tendered in all these cases? And secondly, is it almost certain that prosecution will be resumed because of the current offense?
Nate?
I can answer the first question, and I think probably one of the practitioners could better answer the second question. But the answer to the first question is yes. A guilty plea is offered and a factual basis is supplied, and the court finds that the factual basis is adequate. So essentially the prosecutor's job is done. So all that needs to be done in the future then is to accept the guilty plea and enter conviction, which is not done at that point. Instead, state adjudication is stayed. So that's why it's called a stay of adjudication on different probationary conditions.
And Commissioner Ladd, could I ask you to respond to the second question? So if a person has a violation on stay of adjudication, would one of the outcomes of that typically be that you would then go ahead and resume prosecution on that original case?
Sure, thank you, Madam Chair. Just want to clarify, when there is a guilty plea that's taken and the court stays and suspends that during the pendency of the stay, that is what we're talking about with stays of adjudication. I think how Commissioner Fraze has asked the question, he's referring more to what we refer to as a continuance for dismissal, which basically means that the case pens. There's no admission by anybody. There's nothing that's happening by the court. There's no probation. There's no monitoring. And if after a certain period of time, there aren't any similar violations of the law, the matter gets dismissed. There's nothing to resume under a stay of adjudication because the case has already been done. What happens is there's a revocation proceeding in front of the court, and the court determines the consequence for violating the terms and conditions of probation, one of which is imposing the conviction and additional sanctions or consequences. So the only difference between the stay of adjudication and the actual sentence that's pronounced is that the proceedings are stayed and suspended. So there's nothing to resume. We are subject to a probation process with stays of adjudication. So I'm not sure if that helps clarify it, but kind of the questions that Commissioner Fraze asked are more in line with what we refer to as continuances for dismissals, which there's no admissions, and the matter really would have to, the prosecutor would make a motion to resume prosecution because something occurred that violates the terms of that continuance for dismissal, which is different than a stay of adjudication because we've already had an admission and the court just defers entering the conviction.
So you're reminding me that there's a little niggle piece that I really want us to address as part of the comprehensive review, which is that when stay of adjudication, when there is a violation of stay of adjudication, because the sentence has not yet happened, we should clarify in the guidelines that the guideline sentence is what needs to be applied at that point. I don't think that that's always happening everywhere. Commissioner Fraze.
Well, just, I mean, I appreciate Commissioner Ladd, your clarifying that. I guess what I take away from that is that it isn't in this situation with a new offense committed while on a stay of adjudication. It isn't for the prosecutor to resume prosecution. It's for the court to decide whether to enter the conviction and sentence on the old crime. So I guess that it goes back to it's a general problem, I think, with the custody status point, but maybe especially in this case, that the custody status point, if it's going to be applied, is an automatic formulaic thing. There are certain, there's a waiver provision, but it's written pretty narrowly. So we're imposing more severe punishment on the new crime automatically, practically, even though in this particular context, there are going to be serious consequences entered by the court. It's going to enter the conviction. on the old crime. So it means there are consequences for violating the terms of the probation. So I guess I'm really on the fence about this because I take the point about it's not going to take effect until August. We're going to be considering all these issues again. But I guess as I understand it, there's a bit of a turf issue here where the commission has said something that the courts misunderstood and misapplied. And so one way we can look at this is to say, no, this is what we meant, you got it wrong.
All right, so thank you, Commissioner Mueller and then Commissioner Sextina.
Thank you, Madam Chair. Just a couple of things. One piece that I do struggle with, and I'm kind of in agreement on the procedural pieces, being asked to make assumptions, someone new like myself, in terms of the intent, and then, there's commentary based on that language, but we're also made to, kind of assume intent by the Supreme Court. So I kind of feel like procedurally we should wait. And I'm curious, it was brought up on the beds. I may have missed that in the literature and the paper that was submitted. Do we have the bed impact from this, Madam Chair?
Madam Chair, yes. So we brought up a staff paper last time that, so to be clear, the bed impact was 31 beds, and the assumptions on the bed impact were basically that the change in policy from stays of adjudication not counting as custody status to the change in policy, and I just feel the need to say this. There's nothing in our staff paper that in any way quarrels or disagrees with the findings of the rulings of the Court of Appeals of the Supreme Court. We take it that the Supreme Court is accurately construing the text of the sentencing guidelines, but that's all the Supreme Court is doing, is construing the text of the sentencing guidelines. The way statutory construction works is, if the text is clear, you don't need to ask the question, what was the commission's underlying intent? So the problem as construed by the Supreme Court is the text was clear, unfortunately. It was clear in a way that the commission never intended at any point in time during the various multiple changes that were made to Section 2B2 of the sentencing guidelines. It never actually intended this result, but unfortunately, the result that the Supreme Court came up with was a clear result. So based on the change of policy from staff's understanding of the commission's intent, which we put in all our trainings, is that custody status no longer qualifies. It used to be 152.18 custody status qualified. Now, after 2019, no custody status qualifies, to a new policy change where all custody status qualifies, which has actually never been the case. It was only 152.18 previously. Now it's after Woolridge Carter, the guidelines are construed as all custody status qualified. Certainly, there's never a vote of the commission for that. But we estimate that would cost 31 prison beds. So that change from basically, let's say before 2023, when the Court of Appeals decision came out, to the future going forward, there will be a eventual cost of 31 prison beds to fully implement the Woolridge Carter decision. And we take that from basically one county that we believe fully implemented Woolridge Carter immediately after the Court of Appeals opinion, and we're extrapolating from that one county's experience.
Okay, Commissioner Sextina and then Commissioner Larkin.
Thank you. So I think Nate covered a lot of what I wanted to say, probably better than I will here, but I guess as I understand what the motion is requesting, I don't really view it as a change. I don't view it as a departure. I view it as a clarification. And I think it's very common for courts to review legislative enactments or commission enactments and determine that the language is not as clear as the commission intended it to be. And I think it's our job to clarify what the intent of the commission was. And so to me, voting yes on the motion is just clarifying what this commission's intent has always been. I think the staff paper lays that out very well. And, if we, as part of the comprehensive review, decide that our goals are different, we will do that as part of the comprehensive review. But I guess I view this motion as just reinstituting what the commission's intent always was by using clearer language. And so I don't view it as a monumental shift.
Thank you. Commissioner Larkin.
Thank you. And I'll just ask if Nate can clarify the bed impact information, because as I'm thinking about it, and I could be wrong, we've had, for well over a year, the law be that the stay of adjudication generates a custody point. So it seems to me if we're now going to say it doesn't, what we would be doing is reducing the use of prison beds, not increasing the use of prison beds. And so maybe Nate can tell us, those 31 beds, I mean, it doesn't seem that we're increasing anything. It seems like we're decreasing the number of beds that would be used after August if we adopt this change. Am I thinking that through correctly?
Madam Chair, I mean, I think that's true. It depends on what your starting point is. So my starting point is the commission's intent as it was universally understood prior to February 13th of 2023, when the Court of Appeals decision came out. And prior to that point, we would have confidently told anybody who called us, we would have said in all our training, we would have corrected a sentencing worksheet that came through our office. Any attempt to put a custody status point on a sentencing worksheet for a stay of adjudication probation would have been rejected by us. After State versus Woolridge Carter came out in the Court of Appeals level on February 13th, 2023, we sort of held our breath for a while, basically because we knew that was very quickly petitioned for review to the Supreme Court. The Supreme Court accepted review, so we were waiting to see what the Supreme Court's ultimate decision would be. And we set up a sort of an interim process in the meantime for those jurisdictions, and they appear to have been few in number, but some jurisdictions at that point, at least one jurisdiction, certainly Sherburne County, clearly adopted the Court of Appeals decision as being binding. Others, it seems, were waiting for the Supreme Court to finally come through. But yeah, so I think it depends on what your starting point is. The starting point that I'm assuming is the starting point, basically status quo ante before the Woolridge Carter opinions started coming out. And the impact of the Woolridge Carter opinions was 31 prison beds.
And
Or will eventually be.
Yeah, I was just going to add on to that. It usually takes a couple of years to get up to the maximum prison bed impact. So I don't remember how many years this one took, but what he's saying is we're in the middle of that buildup right now. If we change this rule now, then we will cut that off. Commissioner Knudsen, I'm sorry.
Well, it takes more than a couple years to build up. And so that was my question last meeting. When do we reach the 31 beds? It takes many, many years.
Depends.
Those calculations are based on many years out, so we know in the future for budgeting what that's really going to be. So this 31 bed impact that actually will not be in effect until August of 2025. We can change that. We can, by that time, we're going to have an opportunity to do what Commissioner Fraze was talking about, really dive deep and figure out, is this custody status point helpful, useful, meet our public policy goals in all the areas, at all the different crime levels, at all the state levels. Is it something that we want to keep, change, modify, and we can do it holistically? Next question for you, Nate. What do we have pending over the legislature this coming session? We have money. it's our budget, but what else is it?
I mean, it's the budget year.
Are
I
we
mean,
asking for money to continue the holistic review of the guidelines?
yes,
And how much is that?
I'm sorry.
Yeah,
I don't have those.
I don't mean to put you on the spot. It's a significant amount,
It is.
and it's significant for us to reach our goal to do this project and to complete the project. So the issue really is not only how we view things, and this is just a simple change to go back to what it was once before. But now you've got a Supreme Court decision that says no, that custody status point applies. And that's published, and it's an authority. So we are going to be asking, we're having a public hearing at the beginning of the legislative session to reduce or change the decision of the Supreme Court so that there's not a custody status point applied, and we're going to save ourselves 31 beds over a 10-year, 15-year period of time. When it
10 years is
actually,
right.
and we're not in a position where we have to take any action. And I am just concerned how that looks to the public and what impact that public comment period is going to be in the beginning of a legislative session. How is that going to impact the work that we're supposed to be doing in holistically looking at these pieces when we are coming off of a public hearing where we're going to hear a lot, and when we've got a budget over a big request over the legislature. So I feel like we're just kind of stepping into this. And as Madam Chair mentioned, the timing's horrible. I would just urge us to think this through, slow down, and let's look at it holistically and accomplish what our true goals are. Not just quick respond to a Supreme Court decision that is authoritative, that we think got wrong. And then my next question is there other commentary language that we don't think is adequately expressed or written in the text of the guidelines? And that's for another day, but I just hope we consider this. This is not just a quick decision that we should make because that's how we felt before. We're in the midst of it. We got put in the midst of it because our language wasn't clear. The court case, the upcoming legislative session, the requests that we'll be making, the makeup of the legislative session, legislature at this time. I'm very concerned.
All right, well, Commissioner Middlebrook?
Yeah, thank you, Madam Chair. Just to clarify, according to the projections, just to clarify on the prison beds, in 2027, the projection is 20 prison beds. That's still pretty significant. So I think that, that just needed to be clarified. I also would agree with Commissioner Saxena that this amended language is really a clarification of the Supreme Court decision. We're all agreeing that plain language is not, they got that right, but they didn't get to the intent of the commission. So, and again, just emphasizing these are really low level, most of these are really low level drug offenses, and also the other stays of adjudication that are 15218s, those are all done with the consent of the prosecutor. So it has to be. So I think that kind of changes the whole concept here.
All right, and I would just add that, this sort of back and forth between the courts and even legislators, oftentimes language is not written clearly, and the courts call that out when it's true. And then the body that wrote that language has to revisit it and has to fix it. And that this happens every day. This happens all the time. This is not a power grab or anything like that. It's really just trying to clarify that language. So I really don't think it's going to be that big of an issue. I think we should go ahead and call the vote. We have a very full agenda, so I'm going to ask Nate to go ahead and read the roll.
To the Middlebrook motion to abrogate State versus Woolridge Carter consistent with the staff drafted language and subject to a future public hearing. Larkin?
No.
Larkin, no. Phrase?
No.
Phrase, no. Keefe?
No.
Keefe, no. Knutson?
No.
Knutson, no. Ladd?
No.
Ladd, no. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Madam Chair, I think I should take no part in this, given that the discussion of the cases, the Supreme Court case is the focal point of the discussion. So TNB.
So Moore is abstaining.
Moore abstains. Morin? No. Morin, no. Mueller?
No.
Mueller, no. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 4 votes in favor, no votes opposed. I'm sorry, 7 votes opposed.
And with that, the motion fails. All right, so we will move on to the next item on the agenda, which is, oh gosh, now I'm losing my place. There we go. All right, so next item on the agenda. Okay, so before we get to the next item on the agenda, I just wanted to comment. During our last meeting, which was an all-day meeting, we actually spent a great deal of time talking about the comprehensive review and the work that we want to do. We did some really good exercises to identify multiple areas that we want to work on. Some of the big ones were dealing with severity level rankings, our high departure rates, and the offenses that have high departure rates, and criminal history. And so it's time to get working, just as Vice Chair Larkin said earlier, it's time to get working. So today's meeting is the beginning of, we are going to get to work. I also am a chair of another committee, the Community Supervision Advisory Committee, which deals with community supervision issues. And I'm going to bring them here to tell you what we're up to in a meeting coming up here soon. But that committee was tasked by the legislature this past year with working on 11 different areas related to community supervision. And we are on the verge of submitting a report that's actually going to hit 9 out of 11 areas with substantive recommendations. So I know it can be done to do a big project and get big moves on those projects. So I am really excited that we had the energy that we did last time. But it's going to mean, one of the ways that other committee got it done is that we divided and conquered. We had groups working on multiple different things at once. So I think that's what we're going to have to do here. And so some of the agenda today is based on starting to get some of that work in play in multiple arenas. The first item that we're going to talk through here is criminal history. Dr. Laskarensky is going to, Dr. Laskarensky, I'm talking too fast, is going to do a presentation to us on a report that this commission actually received several years ago. But since most people on the commission today were not here then, I wanted to make sure that we got that report again to give us a little bit more information about criminal history before we start talking about that. And then the items underneath that are some action steps to start working on some of those other areas. More information coming in so that we can start working on those other areas. So I just wanted to set the stage that that's what we're starting to do, is get the work going. So with that, I would like to invite Dr. Laskarensky forward or online to come forward to go over the criminal history report with us.
Thank you, Madam Chair, and I'm sorry for your loss. I'm sorry for the commission's loss. And I thank you for having me back today. As as you stated, I'm here to talk about the criminal history score. Some of you, just a couple of you, probably remember that I was here presenting in front of the commission about 8 years ago on this work. And so the work is uses a little bit of a dated sample, but I think some of the concepts are still very relevant. And I think we'll give you some ideas for some of the work that you can start to do around the criminal history score if you choose to do so. And so with that, let me bring up my presentation. I am seeing it on the screen. Is that correct?
Yes, we can see it. Thanks.
Okay. So I think most of you already know me by now, but my name is Julia Laskrinsky. I'm the research director at the Robina Institute, and I'm part of the research team at University of Minnesota, who is here to support the research for the comprehensive review. So let's talk about the Minnesota Criminal History Score and its connection to recidivism. So the role of the Criminal History Score, along with offense severity, the Criminal History Score is used to recommend a sentence based on an offender's prior record. And the commission has said that there are two purposes to the score. The first is to punish repeat offenders based on increased culpability. And the second is to assign more punishment to offenders who are more likely to recidivate. And the reason that that last part is bolded is because the research that I'm going to present to you today is almost entirely focused on this last part. Assigning more punishment to offenders who are more likely to recidivate means that the criminal history score should be able to identify and categorize offenders based on recidivism levels. And so our research questions today are twofold. Number one, is the criminal history score effective in predicting recidivism? In other words, does it work like a risk assessment? Does it identify and separate individuals who have different risk levels? And also, the score is made up of different components. It's made up of 4 different components. And so you can take apart those components to figure out whether how much each one contributes to identifying high-risk offenders, and whether the predictive utility of each component overlaps with the predictive utility of another component. And I can talk a little bit more about what that means. The methodology is, this is a cohort study of the 2003 felony offender sample. So this is all individuals who were sentenced in Minnesota under the under the felony sentencing guidelines. And they were tracked for 3 years. And the recidivism outcome is a felony reconviction. So this is a fairly conservative recidivism outcome. Individuals would have had to have some sort of a reconviction within 3 years to be considered a recidivist. So this is the 2003 sentencing guidelines grid. This is clearly before the drug grid, before the sex offender grid, and so everything was sentenced on here. So each move up in the criminal history score increases the presumptive sentencing range, and it also can push individuals over this disposition line. So if you look there at the top of that matrix, you see that the score goes from 0 to 6, with 6 actually encompassing individuals that also get above 6 points. And you can have increases in the presumptive sentencing range anywhere from 1 month to 20 months at the kind of upper end of the severity level. And so if the score effectively served its purpose of assigning greater punishment to offenders at higher risk of reoffending, we would expect recidivism rates to increase consistently with each successive criminal history score category. So does it do that? It generally does. And this is again according to individuals that were sentenced in 2003 under the grid. Criminal history score levels do correlate with higher recidivism. And so if you look at the figure to the right here, these are reconviction, these are raw reconviction rates, right? So individuals who had a criminal history score of 0 had 15.6 out of 100, about 16 of them recidivist, right? And you can compare that to somebody who had a criminal history score of 6 or above. 48% of them recidivated, 48% out of the sample. The white squares in those in the parts in between just show the difference in the jumps in the recidivism jumps between the scores. And this is just an easy way to show you that the score has some inconsistencies to how well it categorizes recidivists. So the biggest jump in risk of recidivism actually happens at these far ends, where going from a criminal history score of 0 to a criminal history score of 1, there's a 7 percentage point jump. And going from a criminal history score of 5 to a criminal history score of 6, there's almost an 8 percentage point jump. And so to put it in plain terms, on average, out of 100 individuals who have a score of 3, 32 will recidivate, and 36 will recidivate with a score of 4 over the course of 3 years. So they're not huge numbers, but there are some minimal differences between the scores, kind of increasing at those far ends, like I said. And so one question that you may want to ask is, do specific group differences in recidivism warrant greater punishment? And I think probably that answer is yes. And how much more, right? What is the specific increase that you think would warrant an increase in punishment? Is it a 1 percentage point increase in recidivism? Is it a 10 percentage point increase in recidivism, right? And then, of course, the second question is, how much more punishment does being higher risk actually warrant? These are a lot of interesting questions that I'm not going to get into today. And I think you've had, I know Richard Frace has come in and kind of talked about some of the philosophy behind determining the answers to these questions. But I just wanted to put some empirical analysis behind my questions. I want to point out one other kind of interesting analysis of the score. So criminal history score 0 is one of the larger categories. Out of 13,000 offenders, almost 6,000 were sentenced with a criminal history score of 0. But the rate of recidivism between individuals within that score can be actually quite different. Individuals who had, because of the way that the criminal history score 0 is calculated, you can have individuals who have had prior misdemeanors who are still given a criminal history score of 0. And you need, I believe it's, depending on whether it's what type of misdemeanor it is, but you can have up to 3 misdemeanors without actually getting a full criminal history score of 1, right? And so if you separate those out, for individuals that are what you would call true zeros, or they have no prior offenses, the recidivism rate is a little bit low. It's lower than the average for this criminal history score category is 12%. But then if you compare it to individuals who have a criminal history score of 0 but do have a prior offense, and I call these technical zeros, the recidivism rate does go up quite a bit. So so even within a category, there's some differences in recidivism rates. Also, you have this FAR category of criminal history score of 6 and above, and that also encompasses a wide range of different types of offenders, because you are putting in individuals who have who actually have a score of 6 with individuals who have a score much higher but are being categorized as 6. And so you also are going to see some differences in the rate of recidivism within that category as well. Now, this is a pretty small category overall. Under 1,000 individuals are in this category in a sample of 13,000. And so somebody who actually has a true criminal history score of 6, about 41% recidivate, compared to individuals who have 7 and above, over half of them recidivate. So let's talk about the criminal history score components. The criminal history score is made up of 4 main components. That's the custody status point, their juvenile adjudication points, misdemeanor point, and felony points. And so what we can do is to look at how each individual component is related to recidivism. And we can also look at whether or not it actually contributes to predicting, it actually improves the predictability of the score. And what I mean by that is that at a certain point, you can have many different factors inside a risk assessment, but putting more in isn't going to necessarily help you identify more individuals that are more likely to recidivate. And that is frankly just because of overlap, right? If you have individuals that recidivate due to having a prior conviction, adding more points or because they have a different type of conviction or they have a custody status point isn't necessarily going to overall make the model better. And so with a risk assessment, with a lot of risk assessments used in criminal justice today, criminal history score is kind of the main component that is predictive of recidivism, because it does tend to do a pretty good job of predicting future behavior. And then sometimes there are other demographic factors that are added, like age and gender. And so that's not a component of this criminal history score, but you do have these 4 components that are, I think in some cases, not competing with each other, but are just not adding any predictability. And so I play in this report, and I'll link to it at the end of the presentation, I play around with what happens when you remove or change a component, or how a component is calculated, right? And so we'll start with the custody status component. I know in 2019, there was a change, and you were able to add a half custody status point for some offenses. But in 2003, that was not an option, and there was a whole point added if you were if you committed a new offense under supervision. And it did affect a large proportion of individuals. So 1/3 of offenders who were sentenced in 2003 under Minnesota sentencing guidelines received a custody status point. And individuals who received a custody status point were slightly more likely to recidivate than those who did not. And that's true even when I model this outcome, which means that I control for factors that may be related to recidivism of the individuals who have a custody status point. So if individuals who have a custody status point, maybe they tend to be, for example, more male or younger, they're going to be more likely to recidivate anyway. But it would look like the custody status point was related to recidivism. And so I was able to control for some of that as well as some case factors. And the outcome didn't change. Essentially, individuals who received a custody status point were still more likely to recidivate than those who did not. But the recidivism increase was slight. And so if you removed a custody status point from the formula, you would reduce the predictive utility of the criminal history score by 1%, which means that you would be able to ID one less recidivist out of 100. So you would miscategorize one extra person out of 100. But you would be able to move 30% offenders into lower criminal history scores. And because those individuals are more likely to be minorities, you would reduce some racial disparities in sentencing. Juvenile adjudication component is not something that is applied to a large proportion of individuals, just because of the way that it's calculated and kind of the stipulations for when you can add a point. Only 5% of the sample received any juvenile adjudication points, and I think even barely any, I think, received 2 points. I think it was mostly 1%. So oddly enough, individuals who received not a custody status point, a juvenile adjudication point, were actually slightly less likely to recidivate. And we tried very hard to figure out why that is, and we could not. But it is very much the case. Some of it has to do with just perhaps a small percentage of individuals who have it. So if you remove the juvenile adjudication point, it would have no effect on the ability of the score to correctly categorize high-risk offenders. And it would move 5% of the sample into lower criminal history categories. Again, because a higher percentage of minority individuals receive juvenile adjudication points specifically, it would reduce racial disparities to some small amount. We have a misdemeanor conviction component. Misdemeanor point usage: for every 4 gross or serious misdemeanors, offenders receive up to 1 point. And so only 8% of offenders received at least 1 misdemeanor point. Offenders with a misdemeanor point have substantially higher recidivism rates than those who don't. That has to do somewhat with the fact that you have to have multiple prior misdemeanors to receive 1 point. And so it's picking up on that repeat offender effect. And so removing the misdemeanor point would reduce the predictive utility of the criminal history score by 1%. Again, you would ID one less recidivist out of 100, but it would lower the criminal history score for 7% of offenders. And again, it would reduce racial disparities in sentencing. Finally, you have the felony conviction component, which offenders are given half a point to 2 points, depending on the severity of prior felony offenses. Felony convictions are probably unsurprisingly predictive of recidivism of future felony convictions. And so I didn't model what would happen if you remove felony convictions, because I don't think that that's actually a likely outcome of, I don't think that would be an appropriate or realistic thing to model. But you could simplify the criminal history score potentially by removing the weighting of felony convictions. And so instead you could give 1 point for each felony, and you could get rid of all for example. And this is just, again, kind of an exercise to show you what would happen. So completely simplify the criminal history score, give 1 point for each felony, get rid of all the other components. It would have no effect on the ability of the score to identify recidivists, because felony offenses are already a good predictor of recidivism. You really don't need additional types of offenses or types of past offenses to increase the utility of the score. It would move 25% of offenders into a lower criminal history score. It would move 11% of individuals into a higher criminal history score as well. So It would reduce racial disparities in sentencing. And there's one more implication of this, and kind of the last part that I'll, it's part of the analysis that I'll talk about, is that because a disproportionate amount of half-point felony scores are property, are for property offenses, making those offenses 1 point would send more property offenders to prison and for longer. So that is kind of a major implication of this scenario. And on that point, I want to point out one last thing here, is that when you look at conviction type by criminal history score, you notice a couple things. So this is the portion of conviction offense types at each criminal history score. So within a criminal history score, individuals who have a criminal history score of 0, so it's like at almost 0.5% of the sample, 37% are property offenders, 27% are drug offenders, 24% are individuals who have committed a person offense, and 11% fall into kind of that other category. But as the criminal history score goes up, these groups change, and property offenders begin to make up a larger portion of the total group. Right, so at criminal history score 6 and above, almost half of the individuals that receive that increase in the presumptive sentence bump are property offenders. My research also shows that property offenders are more likely to recidivate with another property offense when they do recidivate. And so the criminal history score as is right now, it's particularly good at targeting repeat property offenders for the largest sentencing enhancements. I want to go through I want to suggest some alternative scoring formulations. I just want to say before going through this isn't my recommendation for what you should do as a commission. This is just a recommendation for some ideas that you could discuss, and also to just give you an idea of how what policy changes are available. And this is not a comprehensive list, to say in the least. So some ideas could be to simplify the criminal history score, to streamline it by removing low performing components, such as custody status, such as juvenile adjudications. You could remove felony upweighing, give 1 point for every felony offense, regardless of seriousness, and those two can be put together to kind of to simplify the criminal history score to a large extent. You could combine, for example, criminal history score categories, like, for example, combining category 4 and 5, so that you just have bigger jumps in recidivism before giving an increase in the presumptive sentence length. So an individual would need to be significantly more higher risk to actually get a higher presumptive sentence or to be pushed across that disposition line. You could create, for example, a first-time offender discount for individuals with a criminal history score of 0 who have no priors, who do tend to recidivate at significantly lower rates than individuals with a criminal history score of 0 who do have prior offenses. And you could disaggregate the criminal history score into smaller categories. So, for example, creating a category of, for example, 6 to 8 or 9 and above. And all of these changes, for the most part, would increase prison bed space without substantively reducing the ability of the score to assign more punishment to high-risk offenders, which is the goal of the criminal history score. Okay, I'm going to end it there. a lot of you already have my contact info, but it's already on here. And if you, I know Nate's probably going to send out this presentation, and I want to just link to the report, which is quite a bit more extensive than I was able to present today, but also puts a lot of numbers to some of the statistics to some of the relationships that I talked about, and just provides a lot more information.
All right, thank you. Thank you, Julia. I really appreciate your presentation. Nate, I'm at a disadvantage because my online is restarting. So if anyone raises their hand, please let me know.
Sure.
Any questions for Dr. Laskowski? And Nate, did you want to say something?
Yeah, Dr. Laskowski, on the slide regarding juvenile, the juvenile component, I think there might have been a typographical error on there. Oh, you mentioned the typographical error?
I think I did, yes.
I missed it. So it said custody status, but you meant juvenile.
Yes,
Okay.
I forgot to change that, yes.
Okay, sounds good.
And I am going to fix it, yeah.
Okay, any questions or comments? Commissioner Fraze.
Thank you, Madam Chair. I guess just a couple of things to emphasize from what we just saw. One is that the type of recidivism tends to be property offenses more often than anything else. So what is it we're predicting matters in terms of public safety, victimization, and so on. One of the, there was a slide that showed the difference between exactly 6 points and 7 or more points. And the exactly 6 points was 41%. If you go back to the earlier slide, exactly 5 points was 40.4%. So it's almost flat at 5 versus 6. So I guess another idea, rather than combining 4 and 5, would be to combine 5 and 6, since they have almost identical recidivism rates, and then have the last column be 7 or more. So there's a lot to think about here, especially given, the simplification is always a good thing. I believe in the basic rule of KISS, keep it simple, stupid. And that has always been a goal of the guidelines. And commission is, even though the guidelines are a lot more complicated today than they were in 1980, but nevertheless, simplicity is a virtue. Some complexity is itself a source of disparity. So maybe there are ways we can simplify a number of things, including this part of it.
Thank you. Commissioner Larkin? If you're talking, you're muted. Oh.
I'm talking, I'm sorry. I was just professing my ignorance when it comes to research and science, and just kind of approaching this as a citizen and as a judge who looks at these cases. And sort of consistent with Professor Fraze, well, maybe this is something to think about. Here's what this presentation causes me to think. In the context of, all the information we gathered, including from the judges and practitioners, it would be great to simplify the guidelines, to have less math to do, less things to think about. So where can we do that? It seems to me, one obvious way to do it is to take the juvenile point out, to take the misdemeanor point out. On juvenile points, if it's really a bad actor and it is really something that should be treated as a felony, then they're going to get a JJ status, so they're going to get certified. So I don't have heartburn about taking that out. On the misdemeanors, if they're enhanceable and it's a repeat offender, they're going to repeat and they're going to get up to the felony level of the crime, whether it's a DWI, whether it's a gross misdemeanor, that's going to happen. So I don't have a lot of heartburn about taking that out of the calculation. The one thing that concerns me about custody status point is this, and this, I think, if the public understood better, it would concern them. I don't like the 2-for-1 aspect of it. If you're low-level offender and you get put on probation for a year and a day offense, and you have several of these, and then you get another year and a day offense, until you get to that point where you cross over the line, it's a 2-for-1 deal. You're on probation for one crime, you commit another crime, now you're doing your year and a day for 2 crimes where you're supposed to get a year and a day on 1 crime. So I think that's something we have to keep in mind in terms of how do we deal with this stuff. And maybe the way to maybe what we have to do is have an honest conversation. Are there some levels of crime where it's just like, we can live with that, but for other levels of crime, if we're not going to have consecutive sentencing, if we're not going to really punish you more because you did another crime because it's not within the guidelines list of permissive consecutive sentencing, is that where we need this custody point? Just so it doesn't seem like you're getting the 2-for-1 for your criminal conduct. And again, these are just thoughts I'm having in response to the presentation, and I think it shows some room for compromise, but it has to be in a couple of different areas. So just observations.
Thank you. Any other questions or observations? Well, having known that this research was out there, I just wanted to bring it for exactly this kind of like brain starting exercise that like there are a lot of different ways to think about criminal history, and there's a lot of different effects. So I just thought it was a really good, a good research report for that at this stage. And I really thank you, Dr. Laskarinsky, for taking the time to pull it off the shelf and remind the commission of the work that was done. I appreciate you being here. Oh, Commissioner.
Are we gonna get a copy of that? I think she provided you a copy of the PowerPoint.
I'm sure Dr. Laskarinsky will quickly provide me a copy of the PowerPoint, and I'll pass it along to the commission. Perfect.
That was a lot to digest.
Yeah, it is a lot. Do you mind, could you just click on the link and send that out to the commission as well for the research report? It's posted online.
Yes.
Perfect. All right. In case you want more numbers, Commissioner Knudsen, you can read them. You're like, no, I don't want more numbers. Okay. All right. Next item on the agenda then is severity level rankings. And I think Nate's going to start us off on that one.
Actually, the research staff is.
Oh, great. Perfect.
Let me share my screen. Awesome. Great. So, yeah, I'm Matthew Helena, research analyst intermediate with Minnesota Sentencing Guidelines, and I'm
Jill Payne, senior research analyst with the Guidelines Commission.
Yep. And we're presenting today on high departure rate offenses. We thought that this would be useful for the re-ranking of offenses exercise that's going to be going on. And so, yeah, this presentation, we're reviewing high departure rate offenses over a 10-year period of time from 2014 to 2023. The staff reports on high departure rate offenses in its annual data report, but for only offenses with 50 or more cases in that year specifically. So for this presentation, we're looking at a longer period of time, 10-year period of time, so that we can really talk about offenses that we might have been overlooking in those annual reports. We're going to highlight some of the highest departure rate offenses throughout the presentation, but we've provided an appendix for you all to look at that provides more of a comprehensive overall look at all offenses and the departure rates for those offenses. So the high departure rates that we're going to talk about today involve both dispositional departures and durational departures. And so we thought it would be a good idea to talk about the sentencing grid zones again, so that we can think about, really remind where someone might receive a presumptive commit disposition, and then also where someone might receive an executed prison sentence. And so once again, credit to Professor Fraser for coming up with this concept. This is something Julie and I presented on before, and so we thought it would just be useful to review. So once again, Zone 1 is high severity offenders. So these offenders are recommended prison sentences due to the seriousness of their offense without reference to their criminal history score. And these are severity level 8 offenses and above. Zone 2 is extensive criminal history score. So this is offenders recommended for prison because of their prior record. But for their criminal history, the offender would be in presumptive non-prison zone. Zone 3 is recommended non-prison sentence. These are low severity and relatively low history offenders with presumptive non-prison sentences. And then Zone 4 is the mandated to prison. I see in Zone 3 there's that parentheses area. So that parentheses area is really Zone 4. So those offenses would fall within Zone 3 if not for having a mandate that is a presumptive commitment, or sentencing guidelines policy that is a presumptive commitment. And so for presumptive commitment cases, these would all fall within either Zone 1, 2, or 4. But for executed prison sentences, that could be from anywhere on the guidelines grid, any of these zones. It would be an aggravated dispositional departure to move from Zone 3 to a prison sentence. So just wanted to hone in on those. Now moving on to the meat of our presentation a little bit more. So we're going to start with high mitigated dispositional departure rate offenses. And so once again, these are offenses that did not receive an executed prison sentence despite having a presumptive commitment recommendation by the guidelines. The selection criteria for these offenses was that there needed to be 100 or more cases that were recommended to prison, and that they were sentenced within the last 10 years and received a mitigated dispositional departure rate above 45%. The average for all offenses is 39%. We included that on the slide. But for these 6 offenses, we chose these 6 because we only have so much room on the figure, but also 45% was our cutoff point for this. One other note is that felony DWI and possession of burglary tools, for both of those offenses, this analysis excluded presumptive stays. And with that, I'm going to pass it over to Jill so she can talk about each offense specifically.
Right. Yeah, thanks, Matt. So I'm just going to talk about each of these offenses in a little bit more detail. First, we have assault second degree. That's assault with a dangerous weapon. It has a mitigated dispositional departure rate of 55%. It has a mandatory minimum, so it's in that Zone 4 that Matt described earlier. The mandatory minimum makes it a presumptive commit because of the mandatory minimum, regardless of someone's criminal history. It is a mandatory minimum that the court can sentence without regard to. Up next is identity theft at severity level 8 at 53% mitigated dispositional departure. There are other identity thefts at lower severity levels, but this one at severity level 8 is where there's 8 or more direct victims or a combined loss of greater than 35,000. And then,
one sec before
yes.
you go.
Sure.
It looks like Commissioner Ladd has a question, so I just want to see if it might be related
wonderful.
to
Okay.
anything you've said so far. Commissioner Ladd?
Thank you, Madam Chair. I just wanted to clarify before we got too far down the road here. When you're talking about this assault in the second degree and the mandatory minimums, are you talking about the assault with the second degree dangerous weapon being a non-firearm or other dangerous weapon, or both in this category?
Right. Yeah, that's a great question. We've combined them all for this purpose. We did just because we had an interest, we did look at both severity level, or excuse me, subdivision 1 separately from subdivision 2, and we have kind of a hidden slide later that we can show you, or I'll give you the information for it. So we are combining the dangerous weapons, both the firearms and other dangerous weapons. But if you're interested, subdivision 1, which is the assault with a dangerous weapon, that has a bit higher of a dispositional departure rate at 57% versus assault with a dangerous weapon and substantial bodily harm that has a little bit lower at 43% dispositional departure rate. So the difference with the substantial bodily harm or not did seem to make a difference there.
I guess my question was then, because from a departure rate perspective, a mandatory minimum of 12 months and 1 day for a dangerous weapon or a mandatory minimum of 36 months for a firearm, to me, those mandatory minimums are pretty different with each other in those two groups. And I just was wondering if we broke them down at all, if they're just lumped together, because I think that's telling if we're departing on 12 months and a day mandatory minimum versus a 36-month mandatory minimum.
Right, and here, thank you, that's a great question too. For here, we're not doing that, but it's something we can certainly do. We know the type of weapon, we know whether it's a firearm, a use, firearm possession, or other dangerous weapon use. So it's something we kind of wanted to bring this forward, and then we can certainly follow up on that as well. So moving on.
Yeah.
Okay, thank you. All right, with arson first degree at 51%, and this is arson, also a severity level 8 offense. So it's in that high severity level zone 1. This is arson of a dwelling or other building. And then next, we have failure to register at 50%. Failure to register as a predatory offender. This is on the sex offender grid, and it's at a severity level I, which is at the bottom of the sex offender grid. It has its own row. It's all presumptive commit because it has a mandatory minimum that, again, the court can sentence without regard to that one as well. So those first 4 offenses were all presumptive commitment regardless of criminal history. And as Matt was saying, these next 2, felony DWI and possession of a burglary tool, are lower, below the dispositional line. So it requires criminal history for these to be presumptive commitments, but they are the ones that we're showing you. The first one, felony DWI at 48%, is a presumptive commitment at a criminal history score of 3 or more, or if it's a subsequent felony DWI, there's a policy in the guidelines that says that's an automatic presumptive commit as well. And then possession of a burglary tool is a severity level 3 offense, and that's a rate of 45%. And presumptive commitment at a criminal history score of 4 or more. Okay, next slide. So for these 6 offenses that we just highlighted, the court said in the departure report that the prosecutor either agreed to or did not object to the departure. However, I wanted to point out a couple of rates that for the prosecutor objected, it was a little bit higher for that identity theft at 25% compared to the total 15%. And felony DWI was at 18% compared to that total average 15%.
And if I could just point out that the numbers do not total 100% because judges don't always tell us the position of the prosecutor on the departure.
Great, so that was dispositional departures. We only looked at mitigated dispositional departures for that analysis. Moving on to durational departures, we've looked at both aggravated and mitigated durational departures. So aggravated is more time than what was presumed, and mitigated is less time. For this criteria, we had 2 different types of criteria depending on what type of departure it was. So for aggravated durational departures, the selection criteria was an offense with 50 or more executed prison sentences from 2014 to 2023, and the aggravated durational departure rate was over 10%. For mitigated durational departures, the selection criteria was 50 or more cases with executed prison sentences, and the mitigated durational departure rate was over 30%. And this resulted in 4 offenses for both aggravated and mitigated durational departures. And then once again, I'm gonna pass it back to Jill so she can go over. She knows the offenses a bit more than I do, so pass it back to Jill.
And I was just also mentioned that we have the aggravated durational departure rates in that appendix that's provided in the meeting materials. Aggravated durational departures are in table 7 and the mitigated are in table 6. But first, to go through those aggravated durational departures, these are prison cases only. Unintentional murder second degree, this is at severity level 10. And this is where the person commits or attempts to commit a felony or inflicts or attempts to inflict bodily harm. A 20% aggravated durational departure. Manslaughter first degree at severity level 9 at 19%. This is where the person either causes death in the heat of passion while committing a misdemeanor, gross misdemeanor assault, or malicious punishment of a child. I point these out because there are other severity level manslaughters. Kidnapping, severity level 8 and severity level 9. This is a 16% aggravated durational departure rate. And there's also severity level 6 kidnapping, but for the severity level 8 offense, we're talking about unsafe release or the victim is under the age of 16. And the severity level 9 is great bodily harm. And then last of those aggravated durations at 13% is theft over $35,000. And this is a severity level 6 offense. The theft must be one of a few thefts. One is false representation, swindle, exploiting a vulnerable adult, corporate diversion, or wage theft. Okay, so moving to those mitigated durational departures now. At 40%, there's theft from person. That's a severity level 4 offense. Sex trafficking, this is on the sex offender grid. At 39%, we've got a severity level C and a severity level B. Most of these cases that we're looking at here are the second degree, where the person solicits, induces, or promotes prostitution. And then the less common one is the severity level B for first degree, and it's soliciting, inducing, promoting prostitution, and the victim is under 18 years old at 39%. And then failure to register as a predatory offender. Again, we saw this had a mitigated dispositional departure. It also has a high mitigated durational departure at 38%. And last, aggravated robbery, which aggravated robbery first degree at severity level 8, and that's 35%. So again, just looking at those 4 offenses with less prison time, the court said in the departure report where we had information that the prosecutor agreed to or did not object to the departure.
For maybe both.
What?
Do I call?
Oh, I'm sorry, I didn't see you.
Okay, just before we
Mr.
move
Freeze.
on. The downward durational departure, one of them was theft from the person. And I'm assuming that those are things like purse snatching that would not be considered strong arm robbery, although I guess if there were injury, I would have to assume it would be differently charged. If they're downward departing durationally, it also seems, I mean, we could assume these are not plea bargain down cases that were really robbery cases, because if they were really robbery cases, would they really be willing to not only downcharge it, but depart downward durationally? I don't know, but theft from the person is, I guess, not that common a category here, but I just kind of wondered what's sort of the key piece there.
Don't you have some data on that? Were you talking about that? I thought you did.
Not for this. I mean, thank you, Chair Mitchell. I don't want to speak to how this is charged, but we do have some information on original charges. We haven't done a lot with that to see if the original charging information is different than that, or if it's something where, very often we see that there may be a charge of, this is just as an example, an aggravated robbery, a simple robbery, and a theft from person, and then they may just convict on one of those charges. And if it was that situation, we wouldn't know if there was any change between the charge and the conviction. Does that make sense?
I can speak to the elements of the crime. I mean, the difference between simple robbery and theft from a person basically is force. So if I think a pickpocket probably wouldn't be using force, but a purse snatching, like if there's any resistance at all.
There's actually a Minnesota case on that in my criminal law book about how if there's resistance or anything, then that's force, that's robbery.
Right.
If you can grab it without them even seeing what's coming.
Right. So a pickpocket, or if somebody say has their briefcase next to them at a bus stop and somebody grabs the briefcase, that would be a theft from a person. Doesn't have to be literally on the person, but if there's any force involved, like you say, a struggle or something, then that would be simple robbery.
But if there were injury.
If there's injury, that would be first degree aggravated robbery.
Because if there's injury, there's also probably force.
Yeah. If there's force plus injury plus theft equals first degree aggravated robbery, among other ways to get to first degree aggravated robbery. There are many.
I have also seen that Commissioner Keep has a question.
Yeah, I just wanted to clarify what I heard about the mitigated sex trafficking age range. Did you say it was over or under 18?
For the first degree, it's under 18 years old and solicits, induces, promotes prostitution. That's first degree. Not aggravated first degree, which is something different.
Okay, thank you.
All right.
Sweet. There are no further questions at the moment. We'll move on to the last bulk of our presentation here. And this is where we really combine both of these concepts, the dispositional departures rates and the durational departure rates, specifically looking at mitigated durational and dispositional departure rates to see some offenses which offenses received the recommended guideline sentence the least. And so these are our top 6 offenses in this for this exercise. And so the selection criteria we used for this exercise, once again, was they need to have at least 100 presumptive commitment cases from 2014 to 2023. And the pie here is divided in between received guideline sentence, received probation / mitigated dispositional departure, or received less prison time mitigated durational departure. And for theft of person, just wanted to make another note. We have an asterisk there that this analysis excludes presumptive stays. Also, all of these offenses received the recommended guideline sentence less than 40% of the time.
Yeah, so I was just going to go through each one of them. You can read the pies, but it may be helpful to see that, just to walk you through this. So for failure to register as a predatory offender, what we're saying here is there was 31% of the cases where both the guidelines disposition and duration were being followed. In 50% of the cases, they received a mitigated dispositional departure, so they got probation when they were supposed to get prison. And then for those prison cases, they got less time, 19% of the time. For identity theft, 28% got the guideline sentence, both disposition and duration. 53% got a downward dispositional departure. In 19% of those cases, got less time in prison. Moving to second degree assault, 36% got the guideline sentence, 55% got the dispositional departure. Remember, this is that mandatory minimum offense where it is allowable for the court to give probation instead of prison, but it is a departure still. Theft from person, 36% got the guideline sentence, and 37% got a downward disposition, and 27% got less time in prison. For first degree aggravated robbery, 38% got the guideline sentence, 42% got a probation sentence, and 21% got less time in prison. And first degree arson last, 38% got the guidelines sentence, disposition, and duration. 51% got the downward disposition, and 11% got less time in prison.
Commissioner Ladd.
Thank you, Madam Chair. On the failure to register as a predatory offender, does that include the first-time predatory offenders that have a mandatory minimum of a year and the subsequent ones that the mandatory minimum is 24 months? Are they all in this category or are they separated out?
They're all together for this analysis.
Thank you.
So at this point, we can just pause, and this was really our last slide, Chair Mitchell. But we could also go ahead and do, we've had a little time to think about this, and we did kind of put things into different categories and could kind of do a little bit of a summary if you'd like.
Yeah. You want that?
Emphatically.
Okay.
Yes.
Okay.
All right, but quickly, because we did
Of
have
course,
fun.
of course,
Well,
absolutely.
I don't know if yes, quickly is
Okay, we can
something
do
I
that.
struggle with, but yes. Really, the three categories we came up with for these offenses are, we separate them by how they compare to the average, respectively, for mitigated durational departures and mitigated dispositional departures. So what I mean by that is offenses where the mitigated dispositional departure rate was unusually higher than the average for all offenses. Mitigated durational departure rates that were unusually higher than the averages for all offenses. And then for both offenses where both the mitigated durational and dispositional departures rates were higher than the average for both. And so, Jill?
So I'll say for these three offenses, for identity theft, second degree assault, and first degree arson, we're saying that all three, that these were situations where the duration, the disposition appeared to be what unusually contributed to the high departure for these three offenses. So we've categorized these three together. We can just keep rolling through. Okay. And then for this one in particular, from theft from person, we're saying that it's really the duration that appears to have unusually contributed to the high departure. The 40% mitigated durational departure on those prison sentences, that's the highest we saw. And then our last summary is for failure to register as a predatory offender and first degree aggravated robbery. Here we're saying that both the disposition and the duration is what appeared to have unusually contributed to the high departure.
Thank you. So in the interest of time today, I'm going to lead this discussion a little bit more than usual, just because we have a couple other things to get to. We've talked in our last meeting about how departures are signals that something's wrong. We don't necessarily know what is wrong, but something is wrong. And I can tell you, I had a lunchtime conversation with Mr. Zimmerman, who testified here recently, and I remember him saying to me, asking me the question like, what departure rate is okay? What are we aiming for? And I don't know the answer to that, but I do know that if only a third of the sentences follow the guidelines, that's not what we're aiming for. I don't think that's what we're aiming for. I think we're aiming for something a little tighter. So these high departure rates, I think, are sending us signals that something's wrong, but I think that depending on the offense, there might be something different driving it. The signal might be telling us something different, depending on the offense. And my take is that we need some looking under the hood, a little bit offense by offense, to figure out what those signals are and if there's anything we can or should do about it. Maybe even to come back with some ideas. So I was just gonna, I think this is an area where we should do some further research. And that was really what I was gonna throw out today. It was like, I think we should do some further research. This might be a research project for the U of M team. It might not, but I think that between our research staff and the U of M team, they could figure that out. But I'm just kind of wondering what people think about that. And looks like Commissioner Reeves has a comment and then Nate does too.
Thank you. So especially for the Federal Register, excuse me, my voice, but I supervise level 3 predatory offenders, and I oftentimes agree with departure because you're getting someone that, I have one client that had failed for 3 days and they charged him and convicted him for 3 days not registering. Do I really want to send a client that's in community, in treatment, doing well, and forgot to do paperwork for prison on a mandatory for a few days of not registering and couldn't find it? I think the issue is what we're seeing in terms of why they're not registering. Sometimes you'll have the attorneys will call and say, this is what's going on. Do you think we should charge you? No. There was a mistake. Somebody said they're mentally ill. They forget things. But because it's so strict in that law, they're getting charged. I appreciate the conversation with the attorneys. With them say, well, no, it's not chargeable this time. Keep working with the client. I think that's the issue, is because it's so strict that these departures are going to continue to happen if we make it less strict on how long you have to be out of compliance before you charge someone to sit in prison.
Yeah.
A week seems to be very short, and I have one in 7 days as well. But we're talking months upon months. It's different than someone that gets for a week's time, but it's different to different county attorneys or to different assistant attorneys. Do I do it? Do I not do it? I'm doing everyone. I'm not doing some. There's discretion in that. So I think that's one of the issues in terms of that charge.
And that's the kind of information I think that we could gather. Like what are some of those like real practical reasons that are driving decision-making in the field? Because these all might make sense for specific reasons, but then is there anything to take away from that or do to address that situation and come to terms with the situations that we're actually seeing in the field? I know Nate had a comment and then Commissioner Moore.
Just to follow up on your remarks, Madam Chair, in 2015, the commission was influenced by the fact that I guess to flip it, instead of saying the mitigated dispositional and durational departure rate, the guidelines presumptive sentence rate for first and second degree controlled substance crime was 40%. And based on that, the commission created the drug offender grid, and ultimately the legislature enacted the Drug Sentencing Reform Act. So that 40% number was obviously something that guided the commission at that time.
Mm-hmm. Commissioner Moore.
This is more a question, Madam Chair, maybe for Director Wrights and you. And Director Wrights has hinted at this, interplay between the legislative mandated sentences and the commission's role with regard to the guidelines. And obviously what we're seeing here is judicial, reaction to a legislatively mandated mandatory minimum sentence, particularly on the failure to register. I mean, that's what I saw in the district court. That was the one offense that was chronically being argued for dispositional departures. And I guess maybe it's just more of a question from a policy standpoint. Obviously, we are working within the parameters of what authority the legislature has given us. Is that a message we signal to the legislature if we're essentially disagreeing with, or if we think the data shows that something else should be the mandatory minimum there or some other threshold?
Yeah, I think all of the above could happen, right? Because so for instance, if the research project was to interview judges, prosecutors, and attorneys to find out why all the departures on failure to register and probation, and they came back and with information that showed all these scenarios that are not fitting well within the statute, and these are why the departures are happening, and this might be a better sentence in those cases, then we could recommend that to the legislature so that people wouldn't be in that situation, right? We could recommend a more finely tuned statute that might address multiple different types of failure to register. But I'm just like totally supposing right now. I'm not saying that's what we do.
But that is, I think that gets at the reasons for the departure. And it's just like what Commissioner Reeves is mentioning there. I mean, there are certain practical realities of the world of people that are subject to mandatory registration requirements, and not to suggest that one is more important than the other, but we talk about sometimes more technical, violations that maybe don't have the same effect on public safety as other more serious violations, like where someone literally goes off the grid and we don't know where they are. I mean, that's a big problem, but maybe that's where the focus should be, is tinkering with the particular circumstances that lead to those violations being charged.
Yeah, I think so. And I think Commissioner Ladd brought up some really great points to think about for assault in the second degree too, right? Like the different types of dangerous weapons, the different, the two different statutes, the two different statutory provisions, but even within those, the different ways to commit that offense that, if we looked under the hood, we might see a correlation with the sentences that are actually being imposed. So I think that's what I would ask is that the U of M team and the staff put their heads together to sort of think about how could we look under the hood in more of these offenses. And there's probably more offenses here than we have time to look at all of them. So we probably would need a recommendation too about which offenses we should really hone in on. One thing I do want to throw on the list, because we've had public comment on it a number of times, though, is criminal vehicular homicide. That one has come up a lot, and it's showing up in both places, though it may not hit the threshold to have made it onto the slide today. So that might be one we want to throw on there regardless. But I think if they could give us a recommendation for what to look at maybe at the next meeting, then folks could think about those and think about the other lists that we've gotten today with high departure rates and determine if we need to arrange that list a little bit differently. That's how I would propose that we move forward. Commissioner Middlebrook?
Thank you, Madam Chair. The other question I had, along with the Commissioner Ladd's on the different subdivisions on some of these offenses, is are they first offense or second offense?
Oh, good point.
What's the breakdown on that with these departures?
Right. First time versus second time. It sounds like for failure to register, there's different mandatory minimums there too.
Right. And the same thing with, I think with the ag robbery and the second degree assault. With those, are they the first or second time offenses, or what? Sometimes I think the first offenses that get those dispositional departures.
So some of it we can look at with data, and some of it is more, we need that qualitative information, people's experiences to inform some ideas. But we need both. Absolutely. All right, I'm seeing head nods, so I'm going to take that as a sense. And I'm going to move us on to the next item on the agenda, which is ranking.
Thank you, Madam Chair. So the next item on the agenda is really trying to, it's got two parts. One is sort of the history of how the commission has ranked offenses. And most of the history of the commission ranking offenses has been piecemeal. As the legislature changes an offense or as it creates an offense, the commission ranks it. And we do discuss that in there, but really the focus of the paper is the couple of times that the commission has comprehensively tried to rank offenses, because this is a comprehensive review of the sentencing guidelines. And because offense ranking is one of the two axes of the grid, that's the vertical axis, you know, it seemed like at the last meeting, maybe there was some interest in at least looking at what would be involved in a comprehensive re-ranking of offenses. So we, the first half of the paper really is talking about history and sort of what happened, and there were really two attempts to rank offenses that I found. One was in 1979 when the commission was creating the first sentencing guidelines. So the legislature in 1978 said, we're going to make a Minnesota Sentencing Guidelines Commission. We're going to give them basically a year and a half to come up with the first sentencing guidelines in the nation. So in remarkably short order, they did that. And one of the things they did in remarkably short order was to rank all the offenses. So the first go around didn't work so well, and that was a staff initiated project where basically staff picked 60 felony offenses. It gave each commission member a card deck and said, here, sort these in order of most serious to least serious. And a couple of problems with that. One is I think the 60 card deck, well, I mean, to be quite frank, one of the problems was that one of the commissioners missed that meeting. And that's a problem, right? I mean, we now only have 12 members of the commission. So it's and kind of getting into the executive director's report, I've already reached out to the governor's office and the secretary of state, notified them of the vacancy, and hopefully we can fill that quickly. But some of the other problems were 60 offenses, I think, was just too much for commissioners to digest. It was just too much information, and also it wasn't enough information. There weren't 60 offenses did not include all the offenses that there were. So the commission appointed, dissatisfied with that staff effort, the commission appointed a subcommittee consisting of two people, the prosecutor and the defense attorney. And they came up with, you know, a similar approach to give commission members these, I think they were cards. I don't think Dale Parent's book explicitly says that, but I believe that's what it was. But subdivided them, included more offenses, but subdivided them into manageable categories, subcategories of similar types of offenses. No more than 20 or 21 different offenses. And property offenses were further subdivided into subcategories. And then they were, they kind of dealt with those different property. They called it forgery related and theft related offenses. And they ended up with 3 different lists. Those were kind of all merged into the theft defense list, but in the future. But that's how they did that at the time. So then commissioners had to rank the 20 or 21 offenses in an order of severity, and found that to be a more successful process. Then the commission came back together and ranked, sort of took the different piles and merged them collectively, so that you had a holistic offense ranking from most serious to least serious for all these felonies, with a special way of ranking property offenses. One of the issues that was grappled with, and this is really important, I mean, kind of the 2 central attributes of an offense that have been used for severity are, it kind of makes sense. One is the harm that was caused to the victim, or to whatever the interest was. You know, if the interest is the justice system or the administration of justice, or whatever it might be, you know, fleeing a police officer might be in that justice category. Assault would be in the person category. There's sort of an interest in protecting society from drugs, so that's another category. But whatever the harm is, and then the other thing is the culpability of the defendant. So was this intentional? Was this negligent? You know, what was the defendant, or was the defendant trying to do something and then this ended up happening? Kind of like an assault in the 3rd degree. The intent is to inflict bodily harm. But the harm is substantial bodily harm. So it goes beyond what the defendant intended to do. So balancing culpability and harm turned out to be a big theme. And the original commission, the 1979 commission, didn't prioritize one or the other. It basically, they left it up to the commissions to balance culpability and harm in the offense rankings. So that was the original offense ranking category. And then the fast forward a decade or so into the early 1990s, and the commission was trying to rank offenses as new offenses came up, they were trying to rank offenses basically on people's recollection of 1979, and memories were fading and people were retiring or whatnot. So it was getting frustrating for the commission. So the commission thought, why don't we try to come up with like a really clear set of principles that we can follow for ranking each offense. And that effort lasted several years. And they came up with some really interesting work, but it ultimately was fruitless as far as I can tell. So I don't think any offenses were really re-ranked as a result of this big re-ranking project between 1991 and 1984. And I suspect part of that was how rigid it was. Instead of just identifying the interests protected, and they had these different interests, person, effects of the misuse of chemicals, property, institutional integrity / government process. It also ended up doing a hierarchy of those offenses and said, basically, in general, these types of interests are more important than these types of interests. They also did that with respect to the harm versus culpability. So the commission determined, unlike the first commission, they actually created a little hierarchy there, and they said that harm was more serious than culpability. But I think some useful things is they talked about analyzing the type of harm versus the level of harm. So, and I have some examples of that with the assault in the second degree, where there's a form of assault where the harm is completed and it's substantial bodily harm. So the level of harm would be substantial bodily harm, or the type of harm would be substantial bodily harm. The level of harm would be completed. But then there are other forms of assault where it's attempted or threatened use of a dangerous weapon to cause fear, for example. And so I think it was useful to sort of break out some of those elements of harm and culpability, but ultimately it wasn't, it didn't go anywhere. And I think that may be because it was a little bit rigid. They were trying to basically come up with a numerical score for each offense. And I guess editorializing here, I don't think this is the type of process that really lends it well to a numerical score, and I think that's why it ended up getting crashed on the rocks. Basically, in 1994, they pretty much abandoned the project in early January. So after that, it's been, as I said, and before that, it's been a case by case process of ranking. And the guidelines do have some criteria that I lay out at the bottom of page 5 of the paper. What the guidelines say in section 2A4, there's 4 non-exclusive factors for the court to consider in assigning a severity level to an unranked offense. And the commission can consider that. Unfortunately, some of those are case specific, which the district court has the opportunity to be case specific. The commission has never, you can't be case specific, right? It's creating general rules that apply to all cases. So it typically looks at the typical case rather than the specific case that's in front of the court. So that's basically the history that covers the first 5 pages of the paper. And then the second is just throwing out there a possible approach. Now, this is a staff proposed approach. We know how the last staff proposed approach went. Maybe the last 2 staff proposed approaches didn't go that well, but I'm trying to learn lessons from those prior ones. So maybe it will work, or maybe we can come up with a better process. But this is I think it's a 9-step process. Try not to be intimidated by that. But the first one is form a subcommittee to guide staff. So the subcommittee process seemed to be effective. I think it's probably a good idea to have the subcommittee be. Sorry, I know I'm biased here, but be a little lawyer heavy. The prosecutor, defense attorney, maybe a judge. That seemed to be useful in having these subcommittees, so lawyer practitioners. And then second, this is kind of the big one, where staff with the subcommittee's guidance would try to divide up offenses and define offenses and group offenses to consider how they'd rank. And that table on page 7 illustrates how you might do that with different offenses. So it's got the offense name, and then it's got the statute, the statutory maximum. It's got a description of the offense, and then it lists out the harm type, harm level, and culpability. So those are things that we got from the 1990s process. And you can see the different harm types and harm levels. and culpabilities. And really, if you look at assault in the second degree, and not even getting into Commissioner Ladd's points about the weapon involved, but just the elements of the crime, whatever type of dangerous weapon it is, there's 4 different ways of committing the offense, really, with different harm types and harm levels and culpabilities. So it's just one way to think about that offense, and that's all ranked in that's all severity level 6 in the current guidelines. So there's no distinction between those. And if that's what the commission comes up with, so be it. But I think it would be interesting to break it apart for purposes of this exercise, assuming the commission chooses to do it. So then, like the 79 commission, you'd have step 3 would be the commission takes these little stacks of cards, basically, that have been subgrouped and group them within each stack from most serious to least serious. And that would be an individual exercise among commission members. 4 is you'd come back together, as in 79, and group the stacks basically relative to each other with the commission's agreement based on how the individuals do it. So kind of look at what an average stack would look like and then debate and discuss whether or not they're properly ordered. And then step 5 would be separate the offenses into grids. Unlike the first commission, we have multiple grids now, assuming the commission wants to continue with that. We separate offenses into grids. For example, should failure to register as a predatory offender be on the sex offense grid? The original commission did not consider it to be a sex offense. I shouldn't say the original commission. The commission that created the sex offense grid did not consider it to be a sex offense, but it put it on there anyway because it was related to sex offenses. Some of them are. It's actually not a requirement anymore to be a sex offense. Step 6 then is to rank the offenses by grid. So this is where you merge the stacks together and determine what the total ranking for that grid should be. Step 7, I think a useful step, just because of some of the discussion that came up last month, would be to review low volume offenses and look at sentencing modifiers. And this is where we discuss what came up last month were some unranked offenses, racketeering and aiding an offender accomplice after the fact. With the sentence modifiers, would they be unranked? And look at some other unranked offenses and determine whether they should be ranked somewhere. And step 8 would be assigning severity levels. So basically, now that you've got the relative hierarchy per grid, you'd actually assign them severity levels on grids. And this would be where if you wanted to add or subtract rows from the grid, this is where you determine that. And you'd also look at where is the dispositional line for somebody without a criminal history score. Where's the line where even a first-time offender should go to prison for that offense? That is such a serious offense, a first-time offender should go to prison. And that's the dispositional line. Now, where that line, what it looks like farther down to the right, I think that's really more of an issue for the criminal history project, not the severity level ranking project, but at least where the dispositional line starts, where it crosses the y-axis, basically, that's something that I think is appropriate to do in step 8. And then step 9, take what you've done and compare it to the existing guidelines. And historical sentencing practices, for that matter. Look at the data, look at the sentencing guidelines, and validate. Say, did what we just come up with make sense or not? So that's the paper. And then at the end of that paper is a summary of the principles that were developed as part of I would characterize it as ultimately unsuccessful, but the ranking project in the early 1990s. I think there's some interesting principles and descriptions of, for example, the harm type and the harm level. I think that's something that should be preserved and possibly used as the commission embarks or not on this project. Thank you, Madam Chair. That concludes my presentation on that agenda.
Okay, before we go on, Commissioner Mueller and Keith are in the attendees, so could you elevate them again? Questions or comments?
Well, I think Chief Mueller's on twice. So
Oh, do you think he's on twice?
is he? Yeah, if he's at least he was before. Well, maybe not.
Let it drop off and come back on.
Yeah, he'd gotten on with his phone, so I demoted one of his instances.
Oh, I see.
But I don't see his phone on anymore, so I'm promoting his other instance.
Okay.
Thank you for pointing that out.
Commissioner Knudsen.
Well, obviously, a lot of thought was put into this and much appreciated. I'm sorry, I missed the whole part of the point of the 1990s. It looks like they spent a lot of time, but you said ultimately they weren't successful. It's because they never then carried through and followed up with it, but.
Yeah, I mean, the impression I got from reading some of the minutes was that there was never a real consensus about, how the staff work that's shown in that paper should be applied to cases. And the attempt seemed to be to like come up with a numerical score. And it doesn't sound like the commission really ever had an appetite to do that. So it just kind of died. As far as I know, no offenses were re-ranked due to that.
Other input, thoughts? Commissioner Price.
Thank you, Madam Chair. I guess I didn't hear it and don't remember if I read it. Where does, relating this to what the previous agenda item, how would we factor in departure rates in deciding severity ranking, which I guess is primarily the first of the two issues, that horizontal disposition line, and then it also affects the vertical disposition line for the zones 2 and 3. One way to respond to the signals of the departure rates is to say, well, maybe some of these offenses aren't properly ranked. And a better solution or response would probably be that we just over-aggregated some of these things. We need to break down some of these categories to isolate the cases with the highest departure rate. So maybe it doesn't affect the ranking at all.
Madam Chair?
Yes.
So I think that was envisioned to be in step 9. So, I mean, where you're kind of in the reconciliation stage. So the commission would do this sort of data free, if you'll excuse it. But I mean, just looking at the elements of the crime and disaggregating it if the criminal statute permits. Like, I think criminal statute probably permits disaggregation of second-degree assault into those 4 categories and possibly more if you cross-reference it with 6 and 9/11 and was it a firearm, another dangerous weapon? Was it the first time with a firearm? Was it the first time with another dangerous weapon? So, I mean, there might be other ways of getting into that as well. But just the elements of the crime itself, I think you can look at it. You can disaggregate it into 4 different ways, and that's really why I chose it as an example, because there are 3 different ways of committing an assault, and then this has a 4th way too, where substantial bodily harm results.
And my thought too on that, I think that's a really point well taken, because I struggled with thinking about like what could we get going simultaneously. And I think there's a couple ways you deal with it, that you could deal with it. One is you act like you don't know what's going on with the data, and you just do the ranking clean the way that Nate just described it. The other is you hold those offenses out, rank everything else, and then as we get the information on the high departure offenses, decide what our major approach is going to be with those offenses, and if it is something that ranking might address, then we could fold it in, or if we decide ranking is not something that would address the issue, we then put it in the way it was, like figure out if we want to disaggregate, whatever. So I think you could delay dealing with some of those, or you could adjust later as you get more information on those. But I do think that the advisory committee to the staff could be helpful in deciding or recommending the approach on that too, or sort of giving some guidance on what the best approach might be there. So hearing that this was a high interest item last time, I think we should consider establishing an advisory committee for staff so that they can begin working up some ideas. I mean, we have an idea here, but then like, what does that really mean? Like, start to get into it. So is that an approach that people would agree with? Great. Any volunteers for people who are interested in being on the advisory committee? Okay, so Commissioner Middlebrooks is raising her hand. Commissioner Reeves is raising her hand. Commissioner Larkin, are you raising your hand because you're interested, or you want to say something?
I'm interested because I've said, like, it's a weird, just the way we're structured.
Yeah.
What we need to do doesn't come organically within a big group. We need smaller groups to say, here's an idea. Should we do this? So I think it's a great idea to have a working group, and I'd gladly volunteer for that.
Great. Commissioner Larkin, and then I see Commissioner Ladd's hand up. So are you volunteering?
Yes, I am.
Yes, okay. Okay, so Ladd, Larkin, Middlebrook, Reeves. Is there anyone else?
I'm going to volunteer, Judge Knutson. I mean, here's the reason. I mean, you're in court, you're dealing with these cases, you see what impacts you in decision making. So I think that's an important voice that we need on any working group. I think we need a public or a defense attorney, a prosecutor, and a district court judge, certainly. More so than me. So, I mean, I think those are the important voices.
I was kind of gonna say the same thing, although I would be equally happy if Knutson or Moore volunteered, because both of you, Moore, you've been on the bench very recently. You were a district court judge right before becoming a Supreme Court justice. So.
I was, but I don't have the years of experience in the district court that Judge Knutson does. I would gladly help out, but I sort of was echoing Judge Larkin's thought that I think active district court judge would have a perspective that would be very valuable.
Could I do it?
I love that.
Can I do it?
Okay then. Thank you. All right. I appreciate you volunteering.
Be told and,
Yeah. All right, I think that's all we're gonna do on that one today. And then we are a few minutes over, but I think staff could really use some direction on the next item if people can hang on for a little bit. And is that all right with folks? Okay, so the next item on the agenda is what does the commissioner want included in our comprehensive report to the legislature for this year in our 2025 report? I'll let you take that away.
Yeah, so, and I've got your calendar in there, but just to kind of give you a preview of the next couple of months. There's 6 weeks between this meeting and our next meeting, and then there's 3 weeks between that meeting and the following meeting in January. That's just how it works, and it's all a function of the rules, and we're trying to change that. But so we between now and the next meeting is really going to be focused, I think, on the annual report to the legislature, which is due in December. We don't want to write that thing in January. It's due in January, I'm sorry, but we don't want to write it in January. That would be very stressful on staff. We want to write it, we want to draft it now and basically get all your edits, hopefully all your edits in December. But one thing we wanted your input on before we get to that. Oh, by the way, we'll also talk about the 2023 data. You've already heard some 2023 data, but the data set's now complete and we'll report on that next month. But as Commissioner Knutson has already alluded to, next year is a budget year, and this is an important report to the legislature because in that budget request, it includes phase 2 of the sentencing guidelines. So, while ostensibly the section on the comprehensive review will be reporting on what we've done, the real purpose, in my opinion, is sort of a sales pitch, to be quite frank. So we're basically going to be trying to impress the legislature with all the interesting things and that we've been discussing and learning about and educating ourselves on, and essentially the the outcome is, wow, they're really doing some interesting work. We should fund that work to continue. We thought it would be really, and I should tell you that Matt is going to be writing ghostwriting some of the report for us in terms of what they've been doing. And obviously, you have adopted some criteria by which you were going to conduct the comprehensive review. That will all be in there. But if there's anything else, particularly data or anything else that struck out at you, or anything that you think, oh yeah, definitely put that in there. You don't have to give us all the words, but just give us just some bullet points for us to draft, include in the draft report to the legislature that we submit to you next month. That would be really wonderful. And I know we're over time, Madam Chair, but we would appreciate it if you could give us any guidance at this time.
Does anyone have anything they want to touch on right away? Touch on out loud. Commissioner Reeves.
So you said Matt is going to do a full report of what they're working on?
Yeah, they're going to basically sort of encapsulate. They're ultimately going to do a final report, but this is going to be sort of a preview of their final report on the stakeholder outreach.
That's going to be my question.
Portion of it, as well as the discussion that they led last month.
It's important to have the stakeholder output in the reports. Okay, thank you.
Yeah, I think it's really important to have that included as well. So I'm glad that they're going to be able to do that for us. I would include that. And then I think if there's any, major, at least a description of all the research that the U of M gave us.
Yeah.
Because we've gotten many different presentations over many projects. And hopefully they can help you a little bit with some content there. But I feel like we need to basically make the case. We've done a lot of analysis and received a lot of information and stakeholder input, and they're leading us in this direction. And here are the major topics that we will be diving into in this next phase.
That's the important part is what we're going to be doing with the information. The request that we ask of them to come up with this report and back to it. Excuse me.
Anyone else? Oh, Commissioner Middleton.
We were just talking about, should we include the work we did on the roles?
Oh.
Updating, modernizing, clarifying, in process.
I think that would go in there, wouldn't it?
Yes, yeah, but not as part of the comprehensive review. But
Yeah.
that's,
No, just as part of the report.
For sure. Anything else? Okay. How short is your executive director report?
Just a couple things.
Okay, go for it.
So one is on the rules, we are, well, let me just say, just to get a jump start on the next item, if any members of the public remotely are interested in making comment during the public comment period, please raise your hand. You should all be on a computer, it looks like, so you should all be able to raise your hand. So please raise your hand at this time if you're interested in making public comments. So the public comment, speaking of public comment, the public comment period for the proposed changes to the rules is coming up later in the month. Next week, I am meeting with the revisor's office to see how they're progressing as far as their take on the rules and what changes they're going to be making. So, hopefully we're getting close to moving on to the next step. I don't know how far along the revisor's office is, but if they're probably trying to wind it down before the session because they get pretty busy during the legislative session. So hopefully they can wrap it up soon, and then we can move on to the next stage in the process and actually adopt some rules. The second thing, and this is really important, is the meeting will not be in this room next month. So the meeting is going to be one floor down in a training room called a TASCA. Basically just follow the signs to DOC Commission Room. They're currently remodeling that room, and by remodeling, redoing all the technology and everything in that room. And this room then will be closed so they can do the same thing to this. So we'll get a taste of what that's going to be like what this room will be like in the future next month when we go down to Itasca. But the room is similarly sized to this room, I would say. It's a little different layout, but I don't think it'll be too hard to adjust. That concludes my report, Madam Chair.
Okay. And let's open it up for public comment. Is there anybody who who's interested in making a comment today? I think if Nate asked that you might raise your hand if you are.
Madam Chair, it doesn't look like anyone online has raised their hands.
Not seeing that either. Okay. Well, then I think we have made it to the end of the agenda. Thanks all for your work today. We did a lot and got a lot put in motion, so that's very exciting. Unless there's any objection, I will adjourn the meeting until December 19th. We'll see you then.
What about number 8 on the agenda?
Oh, yeah, you were going to say something about that. Number 8, so I believe the chair was just going to mention.
Oh, I'm so sorry. Okay, let's pretend like I never said the meeting is adjourned. Let's just take that back real quick. Number 8, I apologize, I really missed it. Number 8 is interstate research on out-of-state criminal history and Hernandez. So one of the areas that came out loud and clear is that everybody does not have love for our the way that we count out-of-state offenses in our criminal history rules. And it was suggested that the U of M team might be able to help us understand how other guideline systems do those provisions to see if there might be something we could learn to try to simplify that process. So I reached out and asked Professor Kevin Reitz if he'd be willing to take on that project, and he said yes. And then also suggested that he might look to see if other states have something similar to Hernandezing as well, since that was another issue that came up as a potential thing that we should look at. So I thought, sure, that sounds great. Why don't you look at both? So Professor Reitz agreed to go ahead and start looking into that and to come back and give us some information on that and potentially some recommendations. So that was just an FYI. We weren't going to talk about anything else there, but I just want to let you know that we have that in motion as well. Anything you wanted to say, Professor Reitz, on that one?
It was a good summary.
Okay. All right. So with that, unless there is an objection, we are adjourned. We'll see you next time.
Thank you.
Thank you.